My name is Justin Myers, and today we are going to talk about the role of a Chapter 7 trustee. This and other topics can be read about in a book I wrote entitled Filing Bankruptcy in Utah. You can order a free copy of this book from utahbankruptcybook.com. That's utahbankruptcybook.com. You can also call my office at 801-308-8200. That's 801-308-8200. And set up a free initial consultation to meet with me to discuss your options. The United States Trustees Office is a branch in the United States Department of Justice. The United States Trustees Office contracts with individuals, usually attorneys across the countries, who act as Chapter 7 bankruptcy trustees. These Chapter 7 trustees do not work for the government. They are usually part of bigger law firms where they work by themselves and run their own offices. For every Chapter 7 case that is filed with the bankruptcy court, a Chapter 7 trustee is randomly appointed to the case from this panel of trustees. In most cases, there are different groups of trustees that are assigned to different geographical areas. Once a Chapter 7 trustee is assigned to a case, the trustee first reviews all of the bankruptcy schedules and statements that have been filed in the case. The Chapter 7's trustee's next job is to conduct the 341 meeting or meeting of the creditors. This meeting usually occurs about a month or so after the case is filed. At this meeting, the trustee reviews and verifies the documents and information that the debtor is required to bring to the meeting. The trustee also asks the debtor a series of routine questions, plus any additional questions that the trustee feels are necessary in each case. If the trustee finds errors or incorrect information in the schedules and statements that were filed in the case, the trustee may require the debtor to change and amend the schedules to reflect accurate information. The trustee may also ask the debtor to produce other documents and information at a later date. As soon as a Chapter 7 case is filed, a bankruptcy estate is created. The creation of the bankruptcy estate means that the trustee has the right to administer the debtor's property. Basically, this gives the Chapter 7 trustee the right, under certain circumstances, to take the debtor's property and sell it for the benefit of creditors. Consequently, once the debtor files a Chapter 7 case, and while the case is open, the debtor cannot sell or transfer any property without the permission of the trustee. As mentioned before, one of the Chapter 7 trustees' main jobs is to investigate the assets and property of the debtor to determine if there is any property the trustee is entitled to take for creditors. If the trustee finds available assets, he or she may take them and sell the assets for the benefit of creditors. However, Chapter 7 debtors are entitled to claim exemptions in certain property. Exempt property cannot be taken by the trustee. The Chapter 7 trustee can take and sell homes and vehicles as well as any other non-exempt property. However, the vast majority of people end up keeping their vehicles and homes because there is not enough non-exempt equity for it to make mathematical sense for the trustee to take the property. If a trustee wants to take a home, the trustee needs to sell the home for enough money to pay a realtor and cover all other costs of the sale, pay off all mortgage loans and other liens against the home, and then pay out to the debtor the debtor's properly taken exemption amount, which in Utah is currently $30,000 per debtor who is entitled to the home. If there is enough money left over after all of these outlays to pay something to general unsecured creditors such as credit cards, the trustee may sell the home. For vehicles, a trustee would run a similar calculation in determining whether or not to sell them. The trustee would have to pay an auctioneer to sell a vehicle or incur similar costs associated with the sale of the vehicle, pay off any loans against the vehicle, and then pay the debtor his or her validly taken exemption amount, which is currently $3,000 per person for street legal vehicles where the debtor is on title. That's the Utah exemption currently. If the result of this calculation leaves enough excess money to pay creditors, then the trustee may sell the vehicle. The trustee can take and sell any non-exempt property. Sometimes the debtor's property is not exempt, but if such non-exempt property has a relatively low value, in the trustee's opinion, the trustee may abandon the property. This means that the trustee will not sell the property because it is of inconsequential value, so the debtor ends up keeping it. This judgment call is left up to each individual trustee, so there is no way of knowing exactly what the trustee will do with any particular piece of property. In cases where there are assets and where the trustee chooses to take these assets, the trustee will notify the debtor's creditors so that they can file proofs of claim with the bankruptcy court. A proof of claim is a document where the creditors state how much the debtor owes them. Once creditors have each filed a proof of claim, the trustee then distributes the funds collected from the debtor's estate to each of the creditors in order of priority and on a prorated basis. A Chapter 7 trustee also has powers that allow the trustee to retrieve property that the debtor has recently given away or sold to other people. For instance, if a debtor has repaid a debt to an insider, which is usually a family member, within the past year, the trustee can sue the family member and get the money back in order to distribute it to all creditors in a more equitable manner. This means that if the debtor paid the debtor's mother back $5,000 with his or her entire tax refund within the past year, the trustee will likely sue the mother to get the money back. If it is a small amount, the trustee may elect not to bother with it. The Chapter 7 trustee is entitled to keep a percentage of what is collected, so the trustee is highly motivated to find and take assets. If the debtor is uncooperative in supplying the trustee with information or documentation that the trustee requests, or if the debtor refuses to turn over property to the trustee can file a motion with the bankruptcy court requesting that the debtor's discharge be denied or revoked. This means that the debtor will not obtain debt relief through the bankruptcy and will still owe all of his or her creditors. So it is very important that the debtor be truthful and honest and cooperative with the trustee. The vast majority of Chapter 7 cases filed end up being no asset cases. A no asset case is where a trustee abandons all interest in the assets and the debtor is allowed to keep the property. The American Bar Association estimates that 85% of Chapter 7 cases filed are no asset cases. Dealing with a Chapter 7 trustee can be extremely frustrating at times. This is one of the main reasons that debtors hire bankruptcy attorneys to assist them with the Chapter 7 process. A debtor's attorney deals directly with the trustee and it can assist the debtor in complying with the trustee's demands and requests.